no quiere deal with her. Y porque ella me dijo, well, if this has to do with me, then do network her first, and I'll get her back later. Because she's like, I'm not, so I'll just stay in the system and this and that. That was the last thing she texted me back. So
Good evening, everyone. It is Brian Ponder here, Brian the Credit Lawyer. I call myself the Credit Lawyer because my practice is based in consumer law. Specifically, I deal with credit, debt, and real estate litigation matters. And tonight, we're going to have a very in-depth presentation. And if you would, those of you that just come on, that are just coming on, you can mute yourself, and as soon as you have any questions or anything, you can unmute yourself and jump right on in. But tonight's presentation is going to be great. It's going to be one of our longer ones because we have several things to cover. And yeah, we're going to jump right into it. So tonight's topic is the top 10 credit repair pitfalls and how to avoid them. Obviously, we have a little typo there, but we know we're talking about how to avoid them. And tonight I'm joined by a special guest, Vance Dotson, also known as Vance the Credit Doctor. He's coming to us all the way from Oklahoma City. And what I'm going to do, I'm actually going to go through all 10, and then we're going to back up. And let me see, let me make sure, is that what I want to do? I think we're going to do a little different. Last night I went through all 10, then backed up. What we're going to do, we're actually going to pace ourselves through each one of these top 10s, okay? And we'll make it through. So we're going to pace ourselves all the way through. That way we can sort of get the benefit. And so I'll keep time so we can make sure we get through everything. If we take, we're going to take a few minutes of each. So look, number one. So we're talking about pitfalls. Pitfalls, obviously, are things that can, cause an impediment to your process. A lot of the people here, either you're repairing your own credit or you're repairing credit for someone else. If you're repairing credit for someone else, number one applies to you. Number one, a major pitfall, I would say, would be credit repair laws. When I started repairing credit, it was after I repaired my credit. I repaired my credit back in 2004, November 2004 to be exact, and ended up finishing February 2005 and purchased my first home. Credit score is 494. I brought it up to the low mid sixes, and was able to close on my home. At that point, I became a real estate agent, started helping people do the same thing. I was working in healthcare at the time. And in the course of real estate, I was able to help people with their credit. And then it was going so well, people that were not my real estate client were asking, hey, can you help with my credit? Something told me to look at the law. At the time, I was in Atlanta, Georgia. Come to find out, in Atlanta, Georgia, they have their own credit repair laws. So we have some state laws that say you can repair credit within the course and scope of being a lawyer, real estate professional, credit, consumer reporting agency, banker, but you couldn't outside, in a nonprofit, but you couldn't outside of those. There's about 7 different sectors. And if you did, it was a misdemeanor. So if you repair credit in Georgia, you're not one of those 7 subtitled entities or persons. You're committing a misdemeanor. That could land you in jail for up to 12 months. And so one of the major pitfalls is not knowing the credit repair law. So just in Georgia, that credit repair law is major. You can find yourself in a lot of trouble if you don't qualify within one of those subcategories. The Credit Repair Organizations Act is a federal law that you must follow. And if you don't follow it, you can be liable on the federal level under the federal statute. So very serious, very serious. And MP is reminding us, well, yeah, the state laws Like Georgia, for example, has a statutory provision. Other states, like Vance will talk about in Oklahoma, they have licensure. So you actually have to apply and get a particular license to be able to conduct business as a credit repair organization in Oklahoma. Now, finally, the third thing would be the unlicensed practice of law. Credit repair is not advising people of laws. It's an act of doing things people can do themselves. You're pretty much, if you want to, you can call yourself a power of attorney almost. You're performing acts that people could do themselves, but elect to have you do it. We're gonna let we're gonna bring Vance in here. I'm trying to unmute you. There we go.
All right.
Vance, tell them about your experience with credit repair laws, or how that can be a pitfall. And Vance, by the way, has a credit repair organization. Vance, how many years you been in business?
Since 2004.
Okay, so same as me. So 16 years in credit. And so, how would you say would you say credit repair laws could be a pitfall for a credit repair person?
Yes, because if you, let's say you're going to the furnishers and you're representing a client of yours, and they're trying to basically shake you down to see who you are, you can just present that paperwork that was given to you from the state that says, hey, I'm licensed to do this. And so it cuts a lot of time, because a lot of these companies don't want to deal with you. And so it's very helpful if you go through the procedures to get the license to understand what's going on.
Absolutely. Thank you for that. Number 2, pitfall, consumer laws. Now, a lot of you may say, well, how is that a pitfall? Well, it's a major pitfall if you don't know the consumer laws. In 2020 now, you have credit repair businesses that are what I would call turnkey business. You just pay someone, they're going to sell you their software, and pretty much you plug and play. However, with this plug and play, you still have to understand there's not a template. There's not one template for everything. So if you don't understand the consumer laws, let's see, we got someone with background. Okay, I think I got it. So if you don't understand the consumer laws, when you have new situations come up where you're trying to plug in things to modify your templates, you may not understand if you're doing something right, if something is an issue that shouldn't be an issue, and you can find yourself chasing your tail. So I think it's very important for anyone to understand the consumer laws, not to advise the consumers, but to understand what you're plugging in on these various templates that you have. And plus, a lot of the consumer reporting agencies are kicking out templated letters because it has the right, when it suspects that a dispute is coming from a credit repair agency, they can kick it out. And it's unfortunate, and so you're going to have to go in and modify each letter depending on what the consumer situation is. So the FCRA, which is the Fair Credit Reporting Act, FDCPA regarding debt collection, UCC, which is major in repo, are just just 3 of the laws. You may also use the Fair Credit Billing Act and other consumer laws at the state level that shadow these consumer statutes. So it's a major pitfall if you don't know what in the world is going on. And we'll talk more about that later in some of these letters that use completely wrong laws. Vance, would you agree with the consumer laws being a pitfall?
Yes. I guess in the sports world, it's a guy named LeBron James. I ask just random people, hey, a random client, hey, do you know LeBron James? And they say, yeah, I know LeBron James. Well, tell me how effective of a player would he be if he didn't understand the basic rules to basketball? And they say all the time, not effective. Well, that's the consumer or / credit repair person if they don't know the basic rules to the game, to play the game.
That's right. That's right. And we have a question. Priscilla asks, do you have to be licensed in your state where your office is or where the consumer lives? Priscilla, that's a great question because a lot of people are saying, oh, well, I'll just go to a state where I don't need a license and I'll just help people from there. So Priscilla, that's a great question. You actually need to be licensed where you are, okay? Because even if you're not dealing with people there, because you're conducting that service in that state. So you're doing business in that state. So if you're in Tennessee, you need to be compliant with the Tennessee law if they have a license law. So they may not. They may have just requirements. And so you ask, or it's actually and you need to be compliant with the states in which you're doing business with people. So if you live in a state where you don't need state license or anything particular, if you're going to help a consumer in Georgia, then you need to be compliant with Georgia law. So you have to keep that in mind because otherwise you'll find yourself crisscrossing into some places where you're conducting illegal business there from your home state where you're compliant. And Jonathan Becker, is there a list? I do believe I have a list, a link to a list that I could share, and I'll do that in the WhatsApp group of the list of states with the requirements. Each state is different. So number three, a pitfall is what I call Civ Pro. Now, Civ Pro is what we call civil procedure in law school. Civil procedure in law school. Now, why is that a pitfall? Well, I'm trying to mute someone here. Leverage services. Can you mute yourself? Let's see. There we go. All right, very good. So civil procedure means a lot of these cases, now, whether you're repairing your own credit or whether you're helping someone else, if you're helping someone else, if a legal situation comes up, then they need to be referred to a lawyer, sure. But if you're repairing your own credit, you could repair yourself into court. And what I mean by that is a lot of people grab these debt dispute letters. Well, guess what? A lot of times these debt collectors can't find you. And so by the time you are happy because you purchased a dispute letter to send them, you're giving them your address, you're giving them your personal details. Sometimes they may call you to try to negotiate something. You're giving them where you work. Unfortunately, you shouldn't. And you may find yourself in court being sued for that debt. And so, and on the converse side, if you're following some of the methods that I teach, you may find yourself on the offensive side going after a debt collector for violating your rights. And to be able to do that, you need to know your way around your small claims court. The small claims court are in every county. So whatever county you're in, you can look up and you'll be able to see what the small claim court rules and forms are and procedures are in your county. You want to pull that. A lot of times they have some pro se pamphlets that can sort of walk you through it, but you have to familiarize yourself with it because inevitably either you or someone, a customer of yours, is going to end up in court over these issues. And hopefully it's on the offensive side trying to assert your own rights. State civil procedure is another pitfall. The state civil procedure means when you're in state court. Small claims court is a subdivision of state court. However, state court rules, that's a bigger court. That's a court that's superior to the small claims court. Small claims court is like the people's court. Everything is sort of informal. There's no discovery. This is for actions that are under a certain amount of money. And that's where you want to find yourself if you're on the offensive side, because it's less procedure to get you snagged up. State court, however, has a more expanded breadth of it, of a procedure, rules that apply. You have discovery and everything else. The federal rules of civil procedure governs federal court. Now, the consumer laws that I mentioned just before here, those are all federal statutes, and so they could be litigated in federal court. If you're in federal court, the procedure rules that govern are the federal rules of civil procedure, or the FRCP. So these are some rules that you want to become familiar with, especially small claims court. Most things that go to state court or federal court, you're going to have a lawyer anyway. But if you find yourself getting really deep into some credit repair methods, it's good to understand what these rules are, because you may find yourself suing someone or being sued on a debt. So very important. Now, Vance, I know you've litigated some cases on your own behalf in both federal court and state court, I believe. Is that correct?
Yes, sir.
How important was procedure in those courts? And we're not talking about law. What's the difference? I mean, law, there's law and then there's procedure. Well, how important was procedure to you?
Very important. Let me tell you why. So I believe it was my first. No, it was probably my first or second case. Man, I'm thinking this is probably 15 years ago when I did this. So it was probably my first or second case. I sued a debt collector in small claims for not citing the minimum. Go to court just to understand what was really going on, because, like you said, it's not a lot of pleadings into small claims. So the judge dismissed my claim, and so the debt collector turned around and sued me, and so I had a double violation. Well, I had a violation of not citing the mini Miranda, and then the violation of them suing in small claims court. And so in the state small claim court rules, a debt collector cannot sue in small claims. And so that was another FDCPA violation that I had to transfer over to federal court. So I had them tied two ways: not citing a mini Miranda and suing me in small claims. And so what happened is it was a lot of briefing. So they was claiming, when I took them to federal court, they claim res judicata. And so what that is just, it's a legal term for this issue or your claim has already been taken care of. But that's not true if it's not ruled on the merits of the case. So it wasn't ruled on the merits of the case because the judge wasn't familiar with what I was saying. And so the only way out for that judge was to dismiss the case. And then I had the second violation of the mini Miranda. So, and I had this on recording. So it's very, very important. So like I say, this was, 15 plus years ago. So it's very important to understand the rules of the game before you go into the courthouse.
Absolutely, because you can have the law on your side, you can have a clear violation, but if you're not abreast of the procedure, you can get procedurally beaten in some of these cases. So that's right. I definitely agree with you there. So Civ Pro is a real big pitfall. So understand what Civ Pro is and how to use it to your advantage with respect to credit repair. Number 4, I put regulators. So that can be a pitfall in 2 ways. One, if you're not in compliance, a regulator can come get you. So that's a pitfall. You can be obviously repairing your own credit is not what we're referring to. But if you happen someone else and you're not authorized to do so, or if you are authorized to do so and go beyond the scope of credit repair into unlawful practice of law or something like that, you have various regulators that can be that will knock on your door, that will be at your office or contact you. Now, that's the pitfall. However, another pitfall is not using regulators or enforcement agencies to your benefit. For example, the CFPB, which stands for Consumer Financial Protection Bureau, they're located in DC. They enforce various consumer laws and provisions. Now, the cases they don't take every case. So just because you contact them about your case, you can feel like you're the most violated person on earth. They don't take all those cases, but what they will do, if you file a complaint with them, which is very easy to do, in my practice, I just copy them on my demand letter. And for people that have my book, they understand some of the dispute letters. I have them copied where you can just fax it to them. They will take your dispute, transmit it to the debt collector or whoever you have a grievance with, and ask for their response. Now, again, everyone knows they're not going to take every case. However, the CFPB is very organized, and they take a tally of all the complaints. They take a tally of all the people that don't respond favorably. And ultimately, once you get on their top list of those that have unfavorable complaints, etc., they can come after you. They can come after these debt collectors. When I say you, I'm talking about debt collectors, consumer reporting agencies, other people that are violating consumer laws. So use it to your advantage, CFPB. FTC as well. FTC, again, that's another enforcement agency. Unlike the CFPB, they really don't transmit your complaint as often to the other side for a response. The FTC will evaluate and also tally up these complaints and take action when they feel necessary. But you can still use them. I as a matter of course, I'm always using CFPB, but you can also implement sending a complaint to the FTC. You can do that through their website and the CFPB's website. The Attorney General in each state has a consumer division. So all you have to do is Google it, look it up. In your state, they will likely have a complaint form that you can fill out, or an email, or a fax number. Just like the CFPB, you can send your complaints to the Attorney General. And I recommend all of this be done simultaneously. What I mean by that is, if you're sending a demand, dispute, etc., to a debt collector, for example, and you're trying to demand that they do something, go ahead and copy that to the CFPB and the Attorney General, definitely the CFPB, because the CFPB is going to transmit and ask for a response. The Attorney General, not so much. Again, the FTC and the Attorney General, they're going to compile information. Once it gets piled up, they're going to go after some of these entities. But you want to copy these entities, these regulators, because one, the CFPB is going to ask them to respond, and they're going to respond to the CFPB because they don't want to get in bad favor with them. And two, is going to give you leverage, right? I mean, you have these regulators piggybacking off of your dispute, making them answer. And so that's something you can use to your advantage. Vance, anything you would like to add for that?
Yes. It's in the credit repair business using the CFPB method. I've seen that favorable for the consumer within 3 days.
Absolutely. They're very fast. They're very fast.
Sometimes 24 hours.
Yep.
It all depends on who you're dealing with, how well you articulate your matter. And like Brian said, you really have to use that. That's a lot of things that people don't really do in credit repair that I know of. But yeah, it's very powerful, very powerful. You're going to receive a response within, I'll say, a week, but you'll receive a response from typically the debt collector before you receive the response from the CFPB. But you're going to, typically speaking, not all the time, you're going to receive a deletion, maybe from, the debt collector, because they don't want to deal with these type of complaints.
Mm-hmm.
So having that option is very powerful. And I think in your book, does it cover the steps on how to do that in your book?
Yeah. So in my book, when you're on the chapter 2, like talking about erasing negative information, it shows you how you would fashion a copy of your dispute letter. And now these are just disputes. In my book, I advocate disputing the debt collectors directly and copying the CFPB. I don't advocate sending it just with the CRAs. The CFPB, in my experience, really doesn't even do anything to the CRAs. The CRAs are so big. I think the CFPB is just that's just my experience. So you'll see in my 1692 GB letter to debt collectors, I don't even include. I include the CFPB for those letters, but the CRA letters I do not. And so we also have a question. MP is saying also a BBB complaint department is also valuable. That's true. I personally don't implement BBB because they're not a regulatory authority. I don't think, I think they're reputational, and I want something with more teeth in it. So, but you're correct. The Better Business Bureau will transmit the dispute or issue, but it has no bite to it because they could have a horrible BBB and nothing happened to them. If they have a horrible CFPB, the CFPB may take them to court and go for millions of dollars. So, but you're correct. The BBB is a option, but they're not a regulator. So I really don't implement them. I keep everything pretty clean. Most of the time I just limit it to the CFPB, but in certain scenarios where there's resistance or something like that, I will implement the Attorney General's office. Like I think Vance had a case with Vance one time with unauthorized pulling of a report, and we implemented the Attorney General in that particular case because it's criminal, impermissible use of a credit report. So like only a handful of times will I implement the Attorney General, but I want you to make sure you understand that's available to you. The FTC is available to you. But the CFPB, like Vance was saying, is very responsive. Within 24 hours, they can have a complaint to that debt collector, because if it's in the database, they will send it over electronically by email. So that's a pitfall, but it's also something you can use to your advantage. Number 5, this is what I call fake news. That's a real big pitfall, because if you're new to this industry and you see what's going on the internet, you may get caught up and think that some of this stuff is viable techniques or viable methods that you can use for your business. They are not. The Section 609 letter is garbage. That is not a proper letter to be used. In 609, it corresponds to the Consumer Disclosure part of the Fair Credit Reporting Act. You have to go 2 sections up to 611, which is the actual dispute procedure part. The 609 section, all that says is a consumer may get a copy of their consumer disclosure, or what you think is a credit report. That's all that says. They don't have to send you wet ink signatures of any contracts, anything like that. It only says you are able to obtain a copy of your disclosure from a consumer. What's a disclosure? The consumer reporting agencies have a file they put together. They sell credit reports. They publish credit reports. They disclose to you a disclosure. So that's not the same report that they sell to various entities. It's a disclosure. So there's a difference. Also keep in mind, when you get disclosures directly from the credit the consumer reporting agency, you can't necessarily litigate off of that because it's not published yet. And so while a lot of people don't like to do so, that's why I know, Vance, in your practice, you'll have people there applying for mortgages. You'll look at that mortgage report, a credit report, because that's a real credit report. That's a published report that's actionable. So if you go to Experian and pull your Experian report from Experian, that's not a consumer report. That's actually a disclosure. So you can't say they unlawfully published that. I mean, you can actually look at the inquiries and you can say they did, but that's not actually a consumer report that's been published yet. It's just a disclosure. So you have to keep that in mind. Credit sweeps. That means someone is just going to clear everything off the credit. A lot of that revolves around false identity theft affidavits. Those are illegal in the fact that you're swearing. And if you end up in court with that document, you can't admit into evidence, a sworn false affidavit. So those are dangerous. It become dangerous also if a lot of people go to the police station, file a police report that's false. Well, that's a crime. So credit sweeps, I mean, the word itself is not illegal, but it usually consists of those ID theft, false affidavits, which is criminal. Trade lines. Now, trade lines, they're not criminal. I know there's a case that came out, but people have to understand trade lines in itself are not criminal. They are the sections of the credit report that are in the credit report. That's a trade line. What people are doing is selling authorized user trade lines, which are temporary, which can be used illegally when a lender relies on that particular history, and if something goes wrong, that could be looked on as illegal. So don't subscribe to, all trade lines are illegal. No, it's not the case. It's just that, like anything else, it can be done unlawfully. So I never have been a proponent of buying these temporary trade lines where you can use for 60, 30, 60, 90 days. First of all, it's temporary, it's expensive, it's unreliable. A lot of people's money are wasted because they never report. So, I encourage you, there are several resources where you can get primary trade lines for bad credit that people can use without having to subscribe to these fake authorized user trade lines that you don't know what's going to happen with. Any particular questions or input? Vance, I see a question here. Credit sweep leads to perjury acts no good. That's correct, MP.
Well, yeah, it definitely falls under a pitfall because, like you said, the 609 letter, it has no merit under the law whatsoever. So like you were saying, it's dealing with disclosures. So you only have an action under the law if you're dealing with the disputes under 611. So, or 611 section R, same thing. So you only have an action under section R. So yeah, so credit sweeps is, like you said, someone maybe using an affidavit, polish, and submit it to the consumer reporting agencies with a list of works. Is, let's say back in say like 95 or something, like it was 95 or 96 when they amended the Fair Credit Reporting Act. And so they was tired, Congress was tired of hearing the horror stories dealing with people not able to get their credit reports fixed. So Congress said, if you get this paper or polish, whatever the case is, if you get this without any question within, I believe it's 5 business days, 5 or 4 business days, you have to remove the information. No reinvestigation, conduct. No reinvestigation has to be conducted.
4 days.
Delete it. No if and buts about it. And so, yes, it's 4 days, 4 business days. Yeah. And so, that's typically credit sweeps. The trade lines. So anybody that's repairing their credit, it sort of depends on what you consider repairing your credit. So if you want, I guess, your FICO score to, increase or something like that, what needs to be done is, like Brian said, well, a repo is a trade line. Everything, every information, every piece of information onto your report is a trade line. So what typically people do is, like what Brian was saying, sell out their AU slots or accounts or whatever the case may be. Well, the financial industry is kind of frowning up on it and saying you're not really credit reliable. And so, like you say, it's very expensive. To me, I 100% think it's trash. I don't ever advise anybody to do it, because it's like Brian said, it's very expensive, and you don't know when the information might be reported. And like you said, it's very temporary. And so it's just not a good thing. So really, to secure, I guess, your investment into yourself is to go to a local credit union and say, for example, if you're paying somebody $1,500 for these trade lines, go to a credit union, give them the $1,500 and get a secured credit card, and just keep building from there. Building meaning add more money. You can continuously add more money to that secured credit card. And what happens is, in reality, what bad credit is, or a low FICO score is your debt to credit ratio is high. It's a formula. And so what happens is, with the available credit, let's say the space in between 0 and 1,500, it counterbalance your overall debt to credit ratio, your availability. And so what happens is, your FICO score, your debt to credit ratio goes down, your FICO score goes up. And so that's when you buy your house, car, whatever the case may be. Well, if you keep increasing it, what you're going to see is other credit card companies want to give you offers. So, and what TransUnion, Equifax, Experian, they make money off of selling your information. So opting out in a credit repair process, you really don't want to do that, because that's hindering you for future businesses down the line, and it's going to make you work a lot harder than someone basically that's opt-in, because TransUnion, Equifax, Experian sells your information. And so, say for example, I go to Oklahoma Credit Union, and TransUnion sells my information to Bank of America, and I have, let's say, $5,000 onto the secure credit card. Bank of America is going to send me a pre-approved offer. I apply for it, and they might give me $15,000. They get very aggressive. They get. Well, somebody said comment about opt out and then opt in. I would suggest never opt out, because you're missing an opportunity. You never. TransUnion, Equifax, Experian is in the data business, so they sell your data, rent out your data to somebody else. So if you're in a biking club or something like that, you're going to get junk mail into your mailbox for biking. It's just how that information works. But so it just makes your efforts a lot easier. No, I after reading that comment, I think you should opt. Well, it just depends on your what you want to do. I suggest you never opt out. no, don't. It's just you're not, just never opt out, because you want TransUnion to sell your information to Bank of America, because say if you have $5,000 on a secured credit card, and then Bank of America comes and say offer you 15,000, or Discover, what's going to happen is that's going to happen, and you want the banks to compete for your business, because if Bank of America offer you 15 and you take it, and so Discover comes along and they see you got a $15,000 card, well, they have to go up higher to get your business, and that's how that information works.
Hey, those are some excellent tips, Vance. And so, D. Charles, I mean, you have to evaluate, why are you opting out? Some people may want privacy. They may not want offers. They may, you have some people that cannot responsibly use credit. So if they got, they're offered a $15,000 credit card, what are they going to do with it, Vance? They may go out and spend 15,000. So it's, it's all dependent on you as a person. Vance is looking to, expand his breadth of credit, because he's in business. He owns a logistics company, and so the more access to capital he has, the more business he could do. So those are excellent tips, Vance. I want to go back. We had a question from D. Charles. Brandon Weaver spams the 609 letter. Mr. Ponder, have you ever seen a CRA deny deletions because of for fraud because of the 609 letter? Well, keep in mind the 609 letter itself is not fraud. It's just it's asking for the wrong thing. Some of those letters are asking for documents. Well, the Fair Credit Reporting Act does not require the consumer reporting agencies to provide you anything document wise. So the letter is just improper as far as the statute. It's improper as far as this request. And keep in mind, just like my watch, if my watch broke, if I didn't keep it wound up, it's a Rolex, so it'll stop, right? So it'll be broken. So even twice a day, my watch will be correct, even when it's broken. That's how you can look at that 609 letter. You have some people that say, hey, I was able to use that 609 letter and get stuff on my credit report. Well, again, that's fine. That's normal. A broken watch is right twice a day. That's the situation. The problem with that is, if you don't succeed with that letter, do you have anything to go on? Don't succeed with your 609 letter and come to me, I can't go to court with that. You have to start all over. So it's a waste of time in the sense that you can't really proceed if things don't go your way.
Hey, Mr. Ponder, is it when I speak, do the listeners, do they see my screen?
Yeah.
Okay. So what I want to do is turn my camera around. Can you see my keyboard? I can't see it.
No, because you have that background.
Oh, okay. So well, I don't know how to really adjust it or alter it. So basically what I have in my hand right now, can you see me, Brian?
Not anymore.
Okay, I'm gonna turn it around. So do you see me now?
Yes. And
Okay,
I think you have to go back, like in your Zoom settings, you have to take out the background there, but you may not be able to do it during an active call. But I can see.
Okay, so what I have here is my credit card. So this is what I keep basically all my credit cards at. I have my wallet and my passport and all that stuff. But this right here is over $300,000 in credit. And so I was wanting to turn my camera around. I mean, it's just junk. It's just credit card offers basically. But I mean, it just piles up. I can pick it up. Look, so all of this is just offers. All it is offers. So you want that because it depends. Well, it makes every credit card, whether it's 1,000 or 50,000, it lowers your debt to credit ratio. when you lower your debt to credit ratio,
Mm-hmm.
you increase your FICO score all the time. So that's what you want.
Absolutely. We have a couple questions. I actually didn't mean to skip forward. Priscilla says to opt back in, yeah, opt out screen. Okay. All right. What does opt out really do? So opt out tells the consumer reporting agencies not to sell your information, like Vance was describing, to the people that want to buy it, to give you an offer, to give you a firm offer of credit, insurance, and all that stuff. So it opts you out of that. So it basically tells the consumer reporting agency, take me out of that list of people that you're going to forward to people, because Bank of America, like Vance was saying, is going to come to them and say, hey, you got anybody that has a $5,000 credit card that's paying on time? We'd like to get that information so we can give them an offer. So opting out would stop that transmission of your data to those buyers. Capital One looks at all three CRAs. Someone typed Delvis Kaba. Depends on what credit. Okay, so it was just some comments. And you all are welcome to unmute yourself if you have any questions. You don't have to remain muted if you have questions and you're not shy. You can certainly unmute yourself, and we like to hear different voices here. All right, look, number 6, expectations. That's a pitfall. Why? Because sometimes, well, first of all, if you're preparing your own credit, first of all, you have to understand the limitations, meaning you can't control what everyone else is doing. But if you happen other people, if you have a credit repair organization, you can't have your customers expecting, just because I pay you, everything bad on my credit is going to go away. That is a very big pitfall. It's illegal under the Credit Repair Organizations Act to make any promises like that anyway. So listen, you can have no guarantees on a result. Just like a lawyer, I can't guarantee any result. Why? Because the results depend on what third parties do. Third parties, so the two parties are you and your customer. Y'all can control what y'all do between the two of you. The third party would be, for example, Experian. You can't control what they do. I'm suing them right now because I disputed something with them. They didn't do what they're supposed to do, so we're in federal court right now. So the expectations have to be managed. What you're doing is called ministerial acts. What's a ministerial act? Typing a letter, putting in a copy of their ID, faxing it to the CFPB, closing the envelope, putting a stamp in it, putting it in the mailbox. Those are ministerial acts. That's what you're doing. Set the expectation. Let the people know they're paying you to do an act, not to guarantee a result. That's a major problem, okay? Because guess what? If the thing comes back verified, they're going to say, oh, yeah, I paid you. I want my money back. Well, no, you may have set the wrong expectation. I can't guarantee what comes off your credit. Now, a lot of you are thinking, well, how am I going to ever get business like that? Well, you have to be honest. You have to let them know that, you're going to go through all the steps that they would have to do. And unfortunately, if they don't know how to do it, it's not going to get done. So they're paying you for your expertise and knowing what ministerial acts to perform, right? So that's a major pitfall that you can easily resolve by proper communication and all this stuff can be in writing. You're supposed to have a contract that preferably spells out that there's no guarantee of the result. Okay. Any input on that, Ben?
Oh yeah, that's super important. Not to say you guarantee a result, because that can get you into a lot of trouble in a court. If you are a credit repair organization, you can get sued for 3 times the amount that person gave you if it goes to court, and that can be that can be costly to your business, because you're dealing with lawyers and legal fees, and you have to pay actual damages and stuff like that. And what you said is very accurate. Is you're doing an administrative act. So the person should outline all of that in the agreement, in the service agreement between, the client and the company.
Now, who reads that? Does anyone? Now, you got to keep in mind, no one reads anything. They're going to sign it. They're not going to read it. So the technology is great now. We can send a DocuSign. People can sign it online. So you almost, if you're not communicating with them by phone, you might want to even put a separate piece of paper, just huge letters, separate and apart from the agreement, which is a little dense, to sort of spell this out, because you want to make sure they know. Yeah, right. A disclaimer. Thanks, Vance. That's very good. So, number 7, pitfall, pay for delete. Okay. So, who's surprised that's a pitfall? Anyone in the comment section? Who's surprised pay for deletion is a pitfall? Let's see if anyone understands that. Well, let me tell you why it's a pitfall. We spoke about this on another call. It's a pitfall because most of the time these furnishers, which usually pay for delete is dealing with debt collector furniture, these furnishers, to be able to get their collection or trade line on the consumer report, they have a contract with the consumer reporting agency. And their contract with the consumer reporting agency promises that they're going to uphold the integrity of the credit reporting system by not doing any self-dealings or underhand dealings with consumers, such as delete, because now the integrity of that report may not be what it should be if this furnisher is bargaining with consumers. Because what if they do all the consumers like that? A consumer can have a great report, they're willing to pay for it. Now these bankers and credit companies that are extending credit are furnishing credit to people that really don't have the credit worthiness they look like they have. So hopefully that makes sense. I say all that to say, basically, it's forbidden by the furnisher. So where do you go from there? Well, less is more. They will rather take $0 than any dollars, because if you have my book and my letters, you're going to take a position that what they're trying to collect is unlawful, and you're not giving them anything. And for resolution of your issue with them, they need to delete the debt and stop collecting it. So you're actually going to get further given $0 and trying to pay something to get it deleted. Now, there are instances, there are some companies, obviously, that will offer that. And at that point, if it's offered to you, you can consider it as it's a business decision at that point, if it makes sense. And if you decide to take it, get it in writing, because the last thing you want to do is expend some cash on a trade line deletion, and they get amnesia after you delete it. Because think about it, they could say, well, it was a bona fide debt and we didn't agree to delete it. So if you're going to do that, let it be offered to you and get it in writing. If they don't want to do it in writing, then you need to stick to your guns, give 0, and demand that it be fixed. Obviously, if this is an original creditor, that's not going to work like that. This is a situation where I'm referring to a debt collector, where you're giving them 0. Now, with original furnishers, they can commit errors too that are actionable, but pay for deletion is typically referring to debt collection scenarios. Vance, have you had any experience with this, pay for delete?
Well, I never done it, not one time.
Right.
In the career, I just think it's disputing properly, understanding the FCRA, understanding the FDCPA. You can leverage a lot.
Mm-hmm.
I don't want to say a big case. I have several big cases with the consumer reporting agencies. and I'm looking at I'm pulling up the files, looking at the service agreement between the furnishers and the CRA. So basically, it's a standard application, and typically it says that that the furnishers is going to report and bill on their accounts, and so that typically gets the debt collectors in a lot of trouble because of how the laws is written and stuff like that. And so, but it's super important if you get involved in litigation, especially with the CRAs. You get involved in any litigation under the FCRA, that's the information that you need to basically always request and use that to your advantage.
Right.
So tell me something. This is Maria.
Okay.
I had a charge off with a collector a couple of years back, and what I did a settlement for him to just update the report saying paid.
This is a collection.
Yes, it was a collection.
Oh yeah, a paid collection. I mean, yeah, that's not.
No, it was a charge off.
Mm-hmm.
And then I worked it. I called him. I said, well, if I settle the charge off, can you put paid and take off the charge off? And they did that.
Was it deleted or was it updated to paid?
It was updated to paid.
Yeah, I mean, that doesn't really that's not a negotiation. Obviously, they have to update it to paid when you pay it. So,
yeah, so the charge off came off.
Well, I think what she's saying is the status was changed, but once again,
collection.
Yes,
It's still a collection now. Yeah.
Well, this is the problem with that. It goes back to what I was just saying. Getting the agreement between the CRAs and the furnisher, because they have a quota to meet. Say, for example, if you're a furnisher with experience, I don't know the numbers offhand, but it just says for you to subscribe information, to be a furnisher, whatever, you have to report at least 100 bad items a month. So, like you just said, that charge off information or whatever. So, but typically, you people is worried about a title of a trade line, like a collection or a repo or something like that. So I think the person needs to worry about the paperwork that's inside the file instead of the title of what it's normally about, because I mean that's where the litigation stuff always starts at, is not if it's a charge off. It starts with they're, like you say, under the UCC, they're missing a document that should have been mailed to the consumer. So being a charge off is really irrelevant. So, but it goes back to the agreement from the CRAs and the furnishers. They have to report negative information continuously to them to remain to be a subscriber.
Vance, I'll add, the superior move is for negative information to be deleted. So, going from a charge off collection to a paid collection, I would even revisit that and try to get that thing deleted, because once you have some of these superior credit grantors, they're going to look at that and may want an explanation. Sure, it's paid, but that does affect your credit reputation.
Well, this was an old one, and this was back in the 90s, so
that shouldn't be on your credit report anyway. If it's that old, if it's in the 90s, that should be passed. That should be passed FCRA reporting time period.
Yeah, but let me add to that. If it was in the 90s, are you saying you defaulted in the 90s or you opened the account in the 90s? Because if you opened it in the 90s and you recently deleted, then that's
No,
what he's talking
no.
about.
No, it was like Target and some other card. So after Target or whomever sold it, it went on as a charge off. So I wanted to update my credit, and so I said, well, you say I owe $1,500, but I only have $500. So if I pay the $500, will you say pay? Just pay. Not pay collection, just pay. And that's what they did.
Delbus, I think, is asking, at what point did this account go negative or charge off? What year did it
Who
charge off?
knows? I don't know.
Yeah.
I have no clue.
Yeah, because it doesn't matter when you open the account. It matters when did you mess up on the account and when was the last time it reported that you messed up on the account.
Yeah. Well,
You don't
hopefully
want that on there. That's what Mr. Pond is saying, and I agree with him. I don't want them to just put paid. I want to make sure that whole payment history is wiped out. That it doesn't even show that I messed up.
Okay.
that's something you can revisit for a deletion, especially if it's as old. I mean, if it's as old, I understand the 90s could have been when it opened, but if it's over 7 years, default charge
No, it wasn't within the 7 years. That's why.
is within 7. Okay, well, you still can delete it.
Oh, it's gone.
Oh, good, excellent.
gone.
Let me see. Negative equal bad account, ruining reputation. Okay, well, great. All right, well good.
Question for Mr. Vance.
Yes.
You say you have $300,000 worth of credit cards.
Yes.
Do you rotate your cards?
Okay, so let
Good
me
question.
okay, so she's saying about the credit cards that I have. Do I rotate the credit cards? No, I don't. And so this is how basically it started. Some of them is cash back, a lot of them is rewards. So but to answer your question, do I rotate them? No. So what happens is every year you can get a free credit report from annualcreditreport.com.
Mm-hmm.
Well, no, I don't order it from the website. You just fill out the form, send it in, they send you the reports. So typically with credit cards, you can go 2 years without activity before it's inactive onto your credit report. And so like you say, that's 2 years. And so every year you can order that report. And so this is where people really mess up. You thinking like you have to go to Walmart for activity. No, you can just view your report, send $5 to whoever is on the report. And so if you typically if you do it once, that's good enough for the year. But what happens is, let's say if you do it 3 times, then we're going to use Citibank. Citibank will issue you a $15 check and say, hey, you overpaid. That's good, because what you're reporting, or what you won't report it, is the activity to update. So you don't necessarily have to go to Walmart or go to get some gas or use the card. You don't have to swipe the card for activity. You can just send in a $5 money or a $5 check, $2 check. It doesn't matter. The whole thing is activity. And do I rotate them? No. And that's why I don't rotate them.
Okay. Thank you.
Well, that's pretty slick, Vance. Number 8, pitfall, lawyer up. So how's that a pitfall? Well, people fail to lawyer up. That's a pitfall. Because if you're repairing your own credit, like I said, you're already high risk for getting sued on defaulted debt. Also, for your customers, you should advise them to lawyer up, because guess what? When you're disputing that collection, or when you're correcting their credit report, what are you doing? Updating their address, disputing with their current address. Well, guess what can happen then? They can get served a lawsuit. So if you have my book, chapter 4 talks about lawyering up in advance. Now, I became a lawyer because lawyers are so expensive. you know, but it doesn't have to be that way. People can get a legal plan through their job. They can get a legal plan privately through some of these legal plan companies. They can go to a consumer lawyer that works on contingency. They can find a lawyer, you know, in advance, or you could be well studied. I know Vance, he does a lot of stuff pro se. You become well studied, you can defend yourself. So it's a real big pitfall if you don't really seek legal counsel. A lot of people, I see this a lot in my foreclosure defense practice. You have people trying to fight banks over hundreds of thousands of dollars, almost $1 million properties. It's not a good idea. It's like trying to, fight Mayweather. I understand you real fast with the hands on the bag, but it's a totally different situation when you're going up against an expert. These lawyers, this is what they do every day. So I can look at a letter and see what's wrong, see what the complaint is, So it's very important to lawyer up. If you don't, it's a big pitfall. Even with Vance, he has several lawyers that he consults with in the course of scope of his own credit repair company, his own business. Very, very important.
Brian,
Yeah.
I have a quick question for you. So, if you're a credit repair company, do you recommend to have your client always sign up for Legal Shield?
Legal Shield, for people to know, is a legal plan. I think that's a good idea for a few reasons. And if they do Legal Shield, for example, I recommend they get what's called a trial defense supplement, because if they're sued, they want to have sufficient pretrial hours. Okay. Legal Shield may cost them $300 for the whole year. Or if they add a supplement, maybe, $100 and so more dollars. If they get sued without that legal plan, they're going to have to drop $5,000 just to defend themselves. Okay. So it makes a lot of sense. I would recommend they get a legal plan. They could be Legal Shield. Their job may have a legal plan option, which may be Legal Shield too, or some other legal plan. I absolutely do agree.
Hey, Brian.
Yes.
What did you call that supplement again?
Trial defense, TRIAL, like a trial lawyer.
Gotcha. Okay.
Trial defense, because most of these legal plans come with a good number of hours for trial defense. But for example, the basic Legal Shield plan, I'm aware, only has 2.5 pre-trial. That's enough time to maybe file an answer, not a lot of time to actually litigate. So that trial defense supplement will beef up those trial defense hours. Very important. And it's like having car insurance. You don't feel like you need it until someone hits you and you got a $8,000 repair bill where you could have been paying $30 a month. So it's very important.
Okay. And do you think as a credit repair company, you should also have some type of business account with them?
Absolutely. Absolutely. Great question. Because for a couple of reasons. One, as a business, if something happens and you have to get legal help, you're going to be dropping $1,500, thousands of dollars. Okay. If you're sued as a business, you're going to drop $5,000 to $10,000 to get represented. If you have a legal plan as a business, you could have been paying a few $100s for the year. And if you're sued, it's you may have a flat rate defense, or you may have a lawyer that can write a letter and resolve it without having to drop those big dollars. So you should have a personal plan and a business plan. If you're an entity, you definitely need to have a business plan. A lot of people don't know that your business cannot be represented by you unless you're in claims court in some places. So if someone sues your business in state court, you can't even represent your business. You have to get a lawyer. So you might as well go ahead and get set up for that in advance. And with the world being so litigious, everyone's trying to save costs. So if they, people will pay you for a service, you can do your service perfectly, and they say, oh, well, he took my money before he performed it, and they may try to sue you. So you always want to be lawyered up. It's a major pitfall not to have a lawyer in advance. Remember, if you do it after something hits the fan, it's a lot messier. Okay, so it's a lot more expensive, is what I'm saying. So it's important to do this in advance. Your clients, your business. But yeah, great question. Vance, what would you? Any other questions on that?
Well, yeah. What you're saying is very accurate. I'll chime in basically on a personal experience. So I was dealing with the law firm that's here in Oklahoma. So they believed that I was practicing law without a license. So they sued me and my business. And so it forced me, to have to get a lawyer. But like you were saying earlier, I deal with so many lawyers in Oklahoma City basis that basically I was already prepared. And so that's just, and you don't want to get caught without basically having a lawyer, because you can represent yourself in that matter like I did, but then I had to get a lawyer to represent the business. So you can say, you enter appearance on behalf of yourself, pro se, yeah, but then they're going to get a default judgment on the business. And that's where it gets real ugly. And you just don't want that to happen. So having that legal plan or some a lawyer on retainer, man, is the way to go, because you're dealing with a lot of consumers that really don't know. And so when they go, pleading their case to someone else that's a lawyer or something, they just want to tell the side and say, hey, this person guaranteed this, or this person told me this. And next thing you know, here goes lawsuits flying. And so you want to be prepared for that.
Absolutely.
Okay. And what would be your guys' rule of thumb for a credit repair company to stay clearly within the legal lines, and pretty much, you have that that security of having that, but to avoid needing legal representation, you just want to be on the safe side. What's kind of some rules of thumb to keep in mind?
To even respond and say, hey, I'm right, you're going to have a lawyer.
Right.
So to answer your question, the best way is to lawyer up early, have your contracts reviewed for compliance with the state and federal law, Credit Repair Organizations Act. And so that's probably one of the best ways to be sort of proactive. Even when you do all that, you still want to manage expectations. So your paperwork can be perfect, but your expectations can be off. Remember your advertisements, your ads, what your advertisements, your videos. If they're saying something completely different from your paperwork, that's a problem. So, legal review, legal plan, or some retainer, some lawyer on retainer. You can create your own plan. You can have a lawyer and say, hey man, I'm gonna give you so much money a month. But it needs to be a consumer lawyer that's well versed in defending, these issues. So hopefully that answers your question, right? Does it answer? Did that answer?
I'm sorry. Yeah. Yes, you
Okay.
did.
Okay. Very good. All right. Very good. Good questions. Look, number 9, pitfall, business credit. Well, okay. How's that a pitfall? Well, people have to realize that just if you're on a credit journey and you're trying to accumulate as much credit or have access to capital as possible, at a personal level, it's limited. Okay. Ultimately, all a business is artificial person. So you can recreate yourself, reinvent yourself. However, businesses are much more expansive than a natural person. So personally, you probably limited to your income. However, a business has unlimited income. So when it comes to your personal income, you have a salary you can report, but a business has projections. And so a big pitfall is for people not really diving into trying to to first of all get a business and trying to build that business credit. So, you have limited personal credit, you can have an infinite number of businesses. I mean, you can buy a business every day and build that business up. However, it's only one you. So, so if you have personally $100,000 worth of credit, well, you might be tapped out personally, but what if you create a business and get a business with 100,000? Well, if you got 10 businesses, well, that's $1 million. So, also consumer laws are not applicable to businesses. So when you have a business debt or a business credit issue, you can't utilize these consumer laws to help you. That's something important to know. And also the business credit, unless it defaults, does not show up on the personal credit. So these businesses are like distinct people when it comes to building credit. Vance, did you want to add anything on the business side?
Well, used correctly, business credit, I've seen people, that's under 23, under 22 years old, obtain $3.5 million, $3 million worth of business credit. So used correctly.
They can't do that on the personal side.
No. Yeah. So use business credit. If you know how to use it, it can be very rewarding. But like you said, they don't have if it defaults, you don't have the type of protection with the consumer laws with business credit.
And I'm going to type in a couple of resources, nav.com, creditsecretsbook.com. The creditsecretsbook.com has a business supplement showing you how to build your business credit. nav.com is a free resource that can help you build your business credit because it's done in stages. So I recommend both of those resources on those that's looking to build a business credit. And someone mentions net 30 accounts and all that. Yeah, it's a staged process. So number 10 pitfall, training and education. So how's it a pitfall? Well, easy. I know Vance knows about this because Vance, first thing you did, I don't know if it's first thing, but you invested in a lot of books and training.
Yeah.
Right? This stuff, and again, in 2020, everything is turnkey. Just pay $200 a month. We'll give you everything you need. A lot of people get caught up in the turnkey, just give us our money. We'll give you the software. You don't need no training, no education necessary. Major pitfall. If you're going to do this, even if you're doing it for yourself, you're going to need to understand what the heck you're doing. You're going to have to educate yourself on what you're doing. You're going to have to get trained on how to do it better. Remember, once you're educated, like even law school, you get the education, but where's the training? So that's how you can understand the difference between education and training. Education is, all right, that's the foundation. Training, how long do you train? It never ends. So a lot of you are on my Zooms. I put this together as an education and training vehicle. Some of you right now are being educated. Some of the guys in here, this is training for you because you're hearing a few nuggets here and there that's going to transform your business. Some of you are like, oh, I know that. But y'all picking up a little bit at a time. Well, that's education. But you're also training because I'm giving you methods on doing things. I'm going to be recommending certain books. Some of the books, like we were talking about earlier, about mindset. It may not be anything about credit. You may be like, well, why are you recommending this? I don't do, maybe about mindset. Because if you have the improper mindset, your business is not going to grow, or it's just not going to work. These Zooms are very, very important. Plugging in. If you're a subscribed person, some of these Zooms I chop up, I may put on YouTube, but no one's going to get the full benefit than you being here. Okay, even if I post the whole thing, some of them I do, some I don't. But if you're here and can't interact and have questions, I have your full attention. So that's why some of you have subscribed to this Zoom for this training and education. And I've told you it's going to be a certificate program to where after 5 of these Zooms, I'm going to have quizzes. You're going to be a credit master. No one, I'm telling you, no one's gonna be able to touch you. You're gonna be on a whole different level. Even with that certificate, though, you're gonna have to further your education and training, because trust me, it's extensive. We're gonna take it. We're gonna go all the way up. We're gonna even probably go into the business side of things, but it's gonna be diverse. So you're gonna get a well-rounded training education, but it's very important. So books, reading books, being on Zoom presentations, and you don't have to just be on mine. I mean, I'm a credit lawyer. Before I was a credit lawyer, I was a credit repair. So Vance and I, we were doing, well, not together, but in the same year, we were doing credit repair, remember? And so,
Oh yeah.
but for the past, 7 years or so, I've been practicing law. Okay, so I have a whole different perspective, but you don't have to be limited to me. There's other training out there that you may want to take a look at and compare and contrast, but you want to stay plugged in to this training. This right here, very inexpensive. If you're paying for my time, y'all would be at about $500 right now, almost $500. Okay, because I charge $400 an hour. So this training is very valuable. You're saving a lot of money. You're getting some expert advice. I'm bringing in experts. You're going to have consultants. So, consulting can be anyone. You can consult with Vance. You can consult with me, because sometimes we can't touch on everything that you need touched on in the general group training. And so you seek out consultants. Now, the beautiful part about that is, once you're consulting on something, now you can run a whole business off of a consultation. So that's my top 10. We're going to take, I already scheduled it for 90 minutes, so we have about 6 minutes. If there's some other topics or questions about these things we covered, let's go ahead and have them. You can unmute yourself, come on in, ask your questions, and I'll be happy to talk to you. Let's see. Dun & Bradstreet is a must. Someone says, yes, Dun & Bradstreet, does your credit, Equifax, Experian, all those have some business credit reporting. We have an awesome from someone here. So, yeah, so.
Actually, I do have some. Oh, I'm sorry.
Okay.
You can go ahead.
If you're gonna create a business, either an LLC or a corporation, would you get a lawyer or would you do it yourself?
Well, I wouldn't get a lawyer because I'm a lawyer. So maybe someone else will answer it. I did a video yesterday. You can look on YouTube, but it talks about that, where I do recommend, first of all, you can do it yourself online. You file it, Secretary of State's website, go to irs.gov, get your EIN. But I do recommend that you consult an attorney or CPA to make sure you're getting the right entity that fits your needs. Someone is writing, whether you get an LLC, C Corp, S Corp. Okay. I have an LLP, a limited liability partnership. So you have to consult with, I would suggest, someone to make sure you're getting the right entity that fits.
Where did you send the link? Oh, you texted me. Can you send it to me on WhatsApp so I can join from my computer?
Okay. So let me ask my question. So my question was, if you have someone who fell for the trap and got a letter in the mail saying, hey, we're the collection agency, let's settle this debt. They already signed the form, and then they contact, me to try to repair their credit. Now, do you want them to retrace that and say, hey, I want to cancel any payments towards you guys, and then go after that collection and see if send that letter out that you gave us?
Okay, good scenario. What form did the person sign?
I'm not quite sure.
Like an agreement?
I believe it was to settle the debt for a smaller amount. It was like a medical collection for. They agreed to pay $6,000, and I think the original amount was $8,000.
Oh wow, yeah. So yeah, that's a good question. So I hate when people do that. Can you review this contract that I signed? It's too late, right? But here's the
Yeah.
thing. You got to listen carefully to this one. If they sign something saying they're going to pay, like an agreement, a contract, it has to be signed by the other side and sent back for it to be binding. So if your customer signed something with this company that's like a settlement or agreement to pay, look at it like an offer. And if they have not yet received from that company a signed, a signed document, that same document signed by them accepting your client's offer to settle, your client can at any time until they receive that signed paper back, write and say, I revoke my offer to settle this debt with you, and send it to them. And if your client sends it to them before they send the signed agreement back to them, that offer is revoked and it's dead. It's null and void. That's the terminology. So
Okay. And also, does it make a difference? It was done via DocuSign.
no,
No difference there, right?
yeah. And so even with DocuSign, sometimes these companies forget to sign it themselves. So you have to, take advantage of that. So they would have to, your customer would need to send a revocation letter saying, I revoke my offer to settle this with you. Yeah, therefore we have no contract. And then come in with a dispute letter, 1692G or whoever, a GB letter like mine or something to fight that debt.
Perfect.
Mm-hmm.
Thank you.
You're welcome. Let's see. Just has a question on your credit repair letter for inaccurate info. You have all 3 CRA names. Do I leave it there? No, you would, and I'm gonna change that. No, you would just do one at a time. So you would delete the one that you're not using, but I'm gonna change that because the intent, yeah. But no, you would just send it to one at a time. Saban, you had a question? Let's see. Saban had a question, but he may have left. Okay, I think he left. Let's see. All right, everyone. Don't do yourself, consult your CPA. Yeah. Any other questions?
Yeah, Brian, I got a quick question.
Go ahead, Warren G.
Hey, when does a debt buyer, when they first call you, or actually anytime when they call you, when do they have to give you the mini Miranda? Right away, or can they kind of probe you for information first, or what's the story there?
Right away. Right away.
Okay.
They can't pull information from you and then do it. But when I say right away, you remember they have to make they can make sure you are you, because if they say they're trying to collect a debt or it's about a debt to the wrong person, then that's a violation tue. So it's a little tricky. So they technically could try to say, well, is this Warren? Well, okay, I just need to verify that you're you, or is your social security number in? They may ask you. They may ask. Well, most likely they'll ask you. Can you give me your date of birth and social security number? See, they'll ask you something.
Okay.
Try to identify it, but of course, I would recommend never verifying yourself. So it should not go past that. But so they can ask some identification questions, but the person should not answer it, because they can't. It'd be illegal to say it's about a debt to a person that's not the consumer, the debtor.
All right. Thank you.
Oh, you're welcome. Okay. Well, very good. Great session, guys, everyone, ladies and gentlemen. Thank you, Vance, for your participation. Thank you all for your insightful questions and participation. Everyone stay safe and God bless America. We're done.